October 5th. Sounds like a long time away, but it's not. We have one missing from the add-on. All right, we'll get started. Good afternoon, everyone. I'm Judge Regina Mincy, and we're going to start our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I'll be providing you with a reset date for the SAP, which is October the 5th. I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to have counsel or representation at this time. And most of you by now should know who your attorney is. Also, you have the constitutional right to remain silent. Remember that anything that you state about the facts, the circumstances, and the occurrences of your case can and will be held against you. The state is here listening. So once again, listen to your attorneys. Who do we have first, deputies?
Good afternoon, Your Honor. We're going to go with number 4, Mr. Warner Freeman.
Okay. Position 4, 23 CR 005707B. Warner Freeman, charged with 1 count of criminal trespass, damage to property, 2nd count of willful obstruction of a law enforcement officer. Pretrial.
29 total. Last was 2021. Well, he got a 2021 battery obstruction conviction. 2020 ag stalking obstruction conviction. 2020 simple battery conviction. 2019 theft by taking conviction. 2018 obstruction NOLO. 2018 probation. 2016 burglary conviction. We got a 07 battery conviction and a lot of probation violations.
All right.
Your Honor, it appears that these facts from the incident that happened on May 4, 2021 arise out of the same facts where he was accused under 22 CR 00174. Our office is actually in the process of submitting a no process in this case.
All right. And that's a quick resolution to that. Thank you, Mr. Pierre Thomas.
And Your Honor, who would need to receive, is Ms. Champion the litigation manager today that would receive that?
Yes, she is.
Okay, thank you, Ms. Champion.
Yeah. Welcome back, Ms. Falk.
Good to be back.
All right.
So that's no process?
Yep.
Yeah, next time y'all can just see that. I ain't have to read all that.
I know, right? It's Friday afternoon. Come on, you know.
I was hoping it wasn't going to be on the calendar.
Okay, right. All right. Next time we'll do a little early communication. We appreciate it. That'll save the jail some time as well.
Right.
All right. Who do you have next? Let's see if we can get lucky again. Who you got next?
Okay, we have position number 5.
Okay.
Lisa Norman.
All right, we have 23 CR 005703G. She's charged with 1 count of criminal trespass. Pretrial.
Norman has 9 total. Last was 2020 probation. 2018 probation. She got several probation violations as well. I stopped there.
Okay. State.
Yes, Your Honor. This happened September 21st, 2023 at 694 Delvigny Street, Southwest. Defendant was sitting on the steps. The officer noted that there had been previous DV calls to that address involving the defendant. She claimed she stayed at that location, but couldn't produce any documentation to the officer and was then told to leave. The officer was later called back out to that location when the defendant returned. At that time, the defendant spoke to Marlisha Mitchell, who was the homeowner, who stated the defendant was kicking and beating on the door and threatening her. Ms. Mitchell stated the defendant and she no longer have a relationship and that the defendant is no longer a resident there. This was also, according to Ms. Mitchell, captured on the Ring doorbell camera, and the defendant had been previously issued a criminal trespass from the landlord, Miss Lisa Lewis. We did see the 9 cycles. Many of them were probation violations. We also did not see any DV offenses. The bond is currently set at $600 surety bond. We're agreeable to a $2,000 signature bond through pretrial services. Stay away from 694 Delvigny Street Southwest. No further contact with Marlisha Mitchell. No alcohol, drugs, or weapons. And we are requesting 1-day anger awareness. We would like to sound for Ms. Mitchell at this time.
All right, Miss Marlisha Mitchell. Are you on the Zoom? Marlisha Mitchell. Don't think so. All right, State. I'm sorry.
Good
PD's on.
afternoon, Your Honor.
Thank you, Ms. McLeod.
My client tells me that she and the alleged complaining witness have been in a 5-year relationship. They had a disagreement, and the complaining witness decided to call the police. My client insists that she is a legal resident of that address, Your Honor. She tells me she has somewhere else that she can go, but she will need a one-time police escort back to the location so that she can retrieve her belongings, because they have lived together for some time. So she has belongings at that location. And also her 2-year-old child is there at that location. So naturally, she also has to get her child from the complaining witness. So we are fine with the signature bond, Your Honor, although we would request that it be through the jail, because my client has no cycles involving any kind of domestic violence or anger issues, and that she have the one-time police escort so that she can get her child and get her belongings. Nothing further, Your Honor.
All right, I will order that $2,000 signature bond through. I'm not for sure why we need the monitoring through pretrial if it's a breakup and they're going away. I only have a criminal trespass charge. I don't have anything.
And Your
further.
Honor, my response to that would be there clearly is a difference in the recitation of facts by the state as far as the state of this relationship and the recitation of the facts by the defense as to the state of this relationship. I believe monitoring is necessary to ensure that there is no further harassment of Ms. Mitchell.
Well, my client wasn't harassing her. You know, sometimes when people are unhappy with the status of the relationship, they sometimes call law enforcement and make allegations that are untrue. And this is what my client is saying, that they actually have been in a 5-year relationship and that she has lived there. I mean, the fact that her child is there would suggest that she actually does live there. Nobody's just going to leave their 2-year-old child at a location if they don't live there.
All right, let me ask you this, Ms. McLeod. I did not get the age because I don't have that on my calendar. She's how?
The child is 2 years old.
No, the defendant.
Oh, she's 27 years old, Your Honor.
And does she work?
She is currently unemployed, Your Honor.
Right. I'm going to change it to a $2,000 signature bond through the jail. And I'm going to allow the one-time law enforcement escort in order to return to the property. Do not go back by yourself. You must make sure that you have law enforcement with you to retrieve your personal items. No drugs, alcohol, weapons, or guns while on bond. No further contact from Marlisha Mitchell. Stay away from that incident location 694 address. And I I don't know, she'll be able to afford maybe a one-day anger awareness course with a 2-year-old, but I won't order that at this time.
Thank you, Your Honor.
All right.
Your Honor, we did have an individual I placed in the chat, Yusef Ode. I had an opportunity to look back, and the defendant has bonded out on a $10,000 surety bond through Second Chance Bail Bonds Company.
Okay, and that's
He's not on the calendar. He was supposed to be an add-on, but we just
oh,
had.
that was the one you
I
all
was
mentioned.
just going back and checking.
Okay,
Yes,
right, the one that had, I got you. All right,
but we
thank
do
you.
still have the other add-on.
The other, right. Okay, I just have the one as well. All right, thank you. All right, Deputy, who do we have?
Next, we're gonna go to position number 9, Ms. Brittany Zimmerman. Position 9.
Okay. This is 23 CR 005706H. Ms. Zimmerman's charged with 1 count of battery family violence, pretrial.
Second arrest, 2023 failure to appear.
All right, state.
Yes, Your Honor, this happened on September 21st, 2023 at 960 Sells Avenue Southwest. The officer spoke with the defendant, who stated she was in an altercation with Ariel Zimmerman, who's her sister that she lives with. Miss Zimmerman, Ariel Zimmerman, had visible swelling to her right eye, and when questioned by the officers, she stated she was jumped by the defendant and Zechariah Smith, who is the father of the defendant's children or child, during the altercation. The defendant then claimed she was the only person involved and admitted to punching Miss Ariel Zimmerman in the eye twice, but claimed it was because she was spit upon. We understand that this is the second arrest. We are agreeable to a $3,000 signature bond through pretrial services, 1-day anger awareness, no alcohol, drugs, or weapons. We are requesting a stay away from 960 Sells Avenue Southwest and no further violent contact with Ariel Zimmerman. We would at this time like to sound for Ms. Zimmerman.
Ms. Zimmerman, is it Ariel?
Yes, Your Honor.
And you said no further violent contact?
At this time, they are siblings, and so we are taking that into consideration as well as the lack of the history.
Okay. Don't know if I see anyone on by the last name. Is there Ariel Zimmerman on? All right, go for it, Ms. McLeod.
Yes, Your Honor, my client is 24 years old. She is the mother of a 5-month-old son. My client is very, very distraught right now. When I spoke to her, she was very, very concerned because she was arrested. She had her child with her at the time. They forced her into a police car, and she does not know where her 5-month-old son is. So she naturally is pretty upset. She tells me she was the one who called the police because she has been paying rent to her sister for some time while she was pregnant, so that she and her son could live in this apartment. And she recently found out that her sister was not, in fact, paying the rent and that they were about to be evicted. She said when she spoke to her sister about it, her sister got upset, came over there with another one of her siblings and tried to throw her few things that she has out. So she called the police for help. This is a situation where the victim is now being victimized. She's the one who ended up being arrested. She told me that her sister did in fact spit on her to provoke her or something, but she said her sister spat on her just before the police came, and that was the reason why she struck her sister, because she spat on her. I just wanted to put that on the record, Your Honor, that my client doesn't have a child. She needs to know where her child is. This child is only 5 months old. Nothing further, Your Honor.
All right. And I don't know, the state you have spoken to this victim, is that correct?
Your Honor, if you could just give me a moment, I do not believe so, but I don't want to speak out of turn. So let me just take a quick look.
Okay.
We did call the number. The number was not accepting calls at the time. We sent her a text and an email informing her of the court hearing and requesting that she call us back. But at this time, no, we have not heard from Ms. Zimmerman.
And Your Honor, my client would also need a one-time police escort to get to what few of her things may still be at this location. She's pretty upset because she has stuff there for her child and for herself. And when she called law enforcement for protection, they ended up arresting her.
All right. I'm going to order the $3,000 signature bond through pretrial. I'm going to order stay away from 960 Sales Avenue. I'm going to order the one-time police escort to get her personal belongings as well as her child. I'm going to order no further violent contact with Ariel Zimmerman. And no drugs, alcohol, weapons, or guns while on bond. And that's all I'll order for this time.
And Your Honor, I do understand that we asked for no further violent contact, but given the fact that we have not spoke directly to Ms. Zimmerman, we would like to modify that to no further contact. If Ms. Ariel Zimmerman chooses to have contact with her sister, she can request a modification.
All right, I'll change to no further contact.
I think my client is quite okay with no further contact because she's pretty upset about how she was treated in the situation.
All right. All right, if that's it, that will conclude this matter.
That's per judge.
Per judge, yes.
Your Honor, what was that bond amount? I'm sorry.
3,000 signature through pretrial.
Did Your
I would
Honor,
also like to put on the record that my client's previous arrest was of a failure to appear on a traffic-related offense.
did Your Honor order one-day anger awareness?
I can through pretrial, yes.
Your
Your
Honor.
Honor, my client is not working. If unless this is free, she
It's
got
free.
I believe through pretrial it is.
Trial, it's free. Is that correct? Pretrial?
I'm sorry, what you say, Judge?
Is anger awareness course free through you all?
Yes.
Okay,
Did you order that?
I did. I added it.
It's still no further violent, right?
Yeah,
No
yes,
further
no further.
contact.
No
I'm
further
sorry,
contact.
what is it? I changed that.
Oh, you
No
changed no
further
contact.
contact.
Okay.
Yeah, no further contact. All right.
And Your Honor, I believe that concludes my business before the court today. I did receive information on another person, but I imagine he was probably sent up to felony or something.
Miss McLeod, if you wouldn't mind giving me the name, I can maybe address it.
Okay, yes, I'll tell you the name. Bosley.
Let's see.
Marco
Bosley. Marco Bosley is
You called it out.
Oh,
okay.
you found it out. Okay.
Got
Thank
you.
you.
Thank you.
My business is definitely concluded then. Your Honor.
All right. Have a good weekend.
Thank you. Same to you.
All right. You too.
This
Who
number
we at,
7
baby?
right here? I
I'm sorry.
think this number 7.
Oh,
This is gonna be position number 7, Ms. Reeves.
okay. This is 23 CR 005704F. Neosha Reese charged with 1 count of reckless conduct. I'm sorry, 2 counts of reckless conduct. Free trial.
It's her second arrest. She was arrested on the 8th of this month. Simple battery, family violence. That's of course open in state court. That's a $2,000 pretrial bond. That's it.
All right, state.
Really quickly, pretrial, is it your intention to revoke the pretrial bond?
Yes.
Okay. Your Honor, this incident, and we're speaking about Moesha Reese, correct?
All right.
This incident happens at 681 University Avenue, Southwest Atlanta. Yesterday, officers went and spoke with the leasing managers who had in their possession her 2 children, AR, 2 years of age, and MR, 1 year of age, at the leasing office. Mr. Rick Lang, who is the Fulton County Permanent Supportive housing administrator, stated he had been assigned to the defendant. He advised that the leasing officer received a call from a neighbor stating that 2 children had been left in the house unattended. Both the leasing officer and Mr. Lang had been made aware a few days prior that the defendant would leave the 2 children inside the house unattended, and she was advised at that time she could not continue to do that. The defendant was then called by the officer, asked where she was. She stated she was getting groceries, and when asked where her children were, she hung up the phone. The defendant returned to the location, stated she had put the children to sleep and left to go get groceries, and asked the neighbors to keep an eye out on her children. It was noted by the officer in the warrant that no neighbors were present or had access to the home. DFACS was contacted and the case was relayed to them for immediate assistance. An aunt responded to the scene and the children were released to her aunt. The defendant is, as you've already heard from pretrial, out on a $2,000 signature bond through pretrial services for a fray on September 9th, 2023, that was signed by Judge Law, and it is now 13 days later, and we are back with Miss Reese. There is a $2,500 surety bond that has already been set. We are agreeable reducing that to a $1,000 signature bond. Follow any recommendations of DFACS, that the defendant attend a parenting class that she must complete and provide proof of, and no alcohol, drugs, or weapons. Given that she is already going to have to bond out on her other case and pay that bond, we are not going to add any additional financial penalties to her at this time.
All right. Is it PD Finley?
Yes, Judge.
Hi, how are you?
Good to see you again. I know it's been a while.
Good. Right, it has.
Well, Judge, obviously I was going to ask for a signature bond, so that works with us.
Okay.
But she is, a young lady, 18 years old, and while I do recognize that she was, just incarcerated and just caught a case, she is presumed innocent on not only that case, but presumed innocent on this case, Judge. So I am going to ask for that signature bond. And I do have a good address for her, a good phone number. And she assured me moving forward that once she does get out, that she will respect the legal process and be showing up to court in the future.
All right. And you said she is 18.
She's 18. That's what, yes, Judge, that's correct. She's 18.
Okay. All right. So I'm assuming she won't need a co-signer. Just making sure of that. All right. It's a 2-year-old and a 1-year-old. All right, I will grant the $1,000 signature bond. I'm going to have that signature bond through the jail. I'm going to order no drugs, alcohol, weapons, or guns while on bond. I'm going to order that she follow the DFACS plan for her case with parenting classes, etc. And
Is that 500 each or 1,000 each?
500 each.
Okay.
And I guess order no further violent contact with those 2 minor victims, AR and MR. Is that correct, Deputy Falk?
That is, Your Honor. And you
All right.
order the parenting class as well, is that correct?
Yes, follow any DFACS recommendations or requirements, as well as taking the parenting class.
Thank you, Your Honor.
Your Honor, what's the breakdown?
500
Thank you.
each. All right, does that conclude this matter?
It does. Thank you, Judge.
All right, thank you.
Next, Your Honor, we're going to go to the top of the calendar. That's going to be position 1, Mr. Bailey, Edward Bailey.
Okay. This is 23 CR 005710C. Edward Bailey, charged with 1 count of battery family violence pretrial.
14 total. Last was 2020 probation. 2019 simple battery no load. 2017 theft by taking no load. failure to appear, and a couple of obstructions from 2016. One was a conviction, one was no law. That's it.
All right, state.
Your Honor, the facts of this case is that officers were dispatched to the location in reference to a male beating a woman, the location being 854 Oak Street, Atlanta, Georgia, 30310. Officers spoke with the defendant first due to the victim crying and being in a different state. The defendant advised that he and the victim were together for 4 years and that the victim was expecting his child. He stated that he snapped, and during the argument, he threw water on the victim and he threw her items out of the car. The victim confirmed that the defendant's story was correct and added that the defendant got his hands around her neck where he choked her and she could not get out of the car. The victim had bruising, according to the officers, on both sides of her face, to which she advised came from the defendant. A separate witness, third party, also stated that they witnessed a male putting his hands on the female inside and outside of the car. The witness then said that the victim then ran to them at that point and asked them to call the police. An officer noticed that the victim's belongings were all over the parking lot. Officer also noted that the victim and defendant also have had previous incidences in the past of violence. Your Honor, the recommendation from the state is a $3,000 surety bond, given the history. We attempted to reach out to Bainbridge Municipal Court to see if this was the same victim as the victim in that simple battery case. However, we weren't able to get in contact with them. We're also asking for the conditions of no contact, stay away, a family violence intervention program, and no drugs or alcohols or weapons. At this time, Your Honor, if we can sound for the victim in this case, the victim being Alexis Nailing, Nailing, I believe she's on the call.
All right. And the victim's name again?
Alexis Nailing.
Alexis Neely.
Sorry, I didn't catch that.
Sorry, that was Alexa.
Mhm. That was coincidental. Alexis Neely.
She may not be on the call then, Your Honor.
Unless she dropped off. I don't know if she started out and dropped off. All right, go ahead, Ms. P.D. Abden.
Thank you, Your Honor. My client is 27 years old. He's lived in Georgia his whole life. He graduated from high school. He went to Monroe Community College and he studied music and business. He's gainfully employed. He works at CRG, which is a community empowerment. He does have substantial ties to the community. He denies the allegations. He tells me that this was a misunderstanding. There is no evidence to show that there were actually prior instances of violence between them. And as far as for the bruising, I don't think that would appear immediately after the incident. And like I said, there is no evidence that that occurred from instances of violence involving my client. He's not been arrested since 2020. He did tell me that the probation violation was a misunderstanding, and he does have a minimal criminal history. And so, Your Honor, I'm asking for a signature bond through the jail. He just started working, and he does not have any financial resources to afford a bond. So setting him a bond today would be like no bond at all. It's also my understanding that he would like to have further contact with her. However, since she's not here today, Your Honor, I understand that we may need to order no further contact at this time. He's also okay with a stay away from the incident location. And it's my understanding that they do not reside together.
Okay. I'm going to order a $3,000 surety bond. I'm going to order stay away from the 854 Oak Street. Going to order no further contact with the victim, Alexis Neely. No drugs, alcohol, weapons, or guns while on bond. And that's all out of order at this time. Anything else, counsel?
That's all from the defense, Your Honor.
Nothing
Thank-
further from the state, Your Honor.
All right, thank you.
Next, y'all, I'm gonna go to position number 3, Mr. Emmanuel Fluker.
This is 23 CR 005702F. Charge of 1 count of theft by taking. Retrial.
Fifth arrest. All I saw was 05 arrest. Vehicular homicide, hit and run conviction. That's it. He's recommended.
Okay.
Your Honor, the brief facts of the case is that the officers responded to a domestic call at the location of 1303 Morgan's Landing Drive in Sandy Springs, Georgia, 30350. The victim, while there, advised the defendant moved out a month ago, but showed up asking if he could take a shower at her place. She advised that after his shower, she declined his sexual advances and asked him to leave. The victim then advised that at some point the defendant set her dog's crate, with her dog being a miniature poodle, on the front porch, removed her dog's tracking collar, and exited the apartment with her dog to his vehicle. She advised that she went to the vehicle and that the two began to pull the dog back and forth. The victim advised that she never gained repossession of the dog at that time, and that the defendant fled the scene in the vehicle. Your Honor, we have had the opportunity to speak to the victim. She states that they're no longer in a relationship, they don't live together, and they're sharing no kids. She stated that he did return the dog. She stated that she does want him to stay away and desires to have no contact with him from her residence. The recommendation from the state is a $2,000 signature bond through the jail, no contact, and a stay away from the residence, and no drugs, alcohol or weapons at this time. And if at this time we can sound for the victim, Latrinda, spelled Latrienda, Morgula, spelled Murgula. Sorry if I botched that pronunciation, but we'd like to sound for her at this time.
All right, so Latrinda Murgula or Murgula, sorry if we're mispronouncing your name. I see someone in the chat here for Marco Bosley. Is that the one that bonded out?
Yeah, but they gone.
They gone. You did let them know. Okay.
Shelly probably did, I'm sure.
Okay. All right. Go ahead, PD Abden.
Thank you, Your Honor. We have no objection to the signature bond through the jail. I did speak with the complaining witness about 45 minutes ago. She told me that she did want to get on the Zoom and make a statement, but her kid is sick, so she wasn't able to. She did want me to relay that she does not want no further contact. My client has some items at her house. And so if Your Honor is going to order a no further contact or a stay away, I would ask for a one-time law enforcement escort for him to retrieve his belongings.
All right. I will order the $2,000 signature bond through the jail. I'm going to order one-time law enforcement escort for him to return to get his items from that location. Stay away from the 1303 Morgan's Landing. And no further contact with the victim, Latrinda, and I think it's Murgula, Murgula, I think. And no drugs, alcohol, weapons, or guns while on bond. And that should be it for now.
Next, Your Honor, you have position number 6, Mr. Ortiz. Ortiz Arrieta.
This is 23 CR 005711B. Charge of one count of discharge of firearm on or near public highway or street, and a second count of reckless conduct. Date,
The second arrest, last was 06 out of North Carolina, possession of stolen goods.
okay. All right, State Deputy Park.
Yes, Your Honor. This incident happened September 19th, 2023 at 215 Northwood Drive. The defendant was a victim, a friend of victim Victor Garcia, who was killed at that location. Surveillance footage showed the defendant went into a market next to the club, a club called La Donna, and came out with a candle. He then made the sign of a cross, lit the candle, placed it on a memorial that was there for Mr. Garcia. He then pulled out a handgun, pointed it into the air, and fired it 3 times. Again, that incident was captured on CCTV and disseminated to the officers who pulled the defendant over in a traffic stop yesterday. The defendant was Mirandized, questioned, and admitted to firing the handgun out of respect for his murdered friend. The officer then pointed out that the weapon was fired directly next to a very busy highway, as well as a crowded residential and commercial business district. He was in that that district when he was firing the gun. And as the officer said in the warrant, what goes up must come down in relation, especially to bullets. Although this is the defendant's second arrest, we do have some serious concerns. As you know, the Solicitor General's office does take the use of handguns, especially in such a reckless manner, very seriously. To that end, we are requesting a $10,000 surety bond. That's going to be $1,000 for the discharge of firearms. We did add a charge of reckless conduct. We are asking for a $9,000 surety bond as to the reckless conduct. Stay away from the 200 block of Northwood Drive in Sandy Springs. We're also asking that the defendant surrender any and all firearms to the Fulton County Sheriff's Office and take a firearms safety class. That's all for the state.
All right, PD Finley.
Yes, Judge. Mr. Ortiz is 37 years old. Judge, he is born and raised in Atlanta, so he does have community ties. He's also has a full-time job, works for Roberts Tree Service, where he is a machine operator, and he's been a full-time employee there for a while. As we heard, he does have a very limited criminal record, and what we did hear is far remote. I believe it was 2006, I heard. He does have 2 children, of which he completely supports, and his new wife has kids as well that he also helps support, Judge. Finances are somewhat of an issue in his life, so I am going to ask for a $1,500 surety bond on Mr. Ortiz's behalf.
That incident in 2006, it was dismissed because the officer wrote down insurance tag and my name down wrong. So that case was dismissed. There was no charge for that. Just guessing.
Understood. Understood. Thank you.
All right. I'm going to order the $10,000 surety bond. I'm going to order that would be $1,000 on the discharge of the firearm and $9,000 on the reckless, for a total of $10,000 surety. I'm going to order stay away from the 200 block of Northwoods Drive. No further contact with the victim. The victim.
The victim
no.
is deceased, Your Honor, so there's not a request for any
Deceased.
further contact.
I was just reading that victim is deceased. Sorry about that. So just stay away from that block of Northwood Drive. If he has any other weapons, needs to surrender them all to the sheriff's department within 24 hours of his release. No drugs, alcohol, weapons, or guns while on bond. And I think that's it. Anything else, counsel?
Nothing further. Thank you.
Just as to the firearm safety class, Your Honor.
I would order that. I just don't know the information, or do they know where to go take it, but I will order a firearm safety class.
Thank you, Your Honor.
Mhm.
You got it. Perhaps. Yeah, whatever. Next, Your Honor, this is gonna be position number 8, Mr. Jarvis Woodard. Yes,
And Your Honor, before we start on Mr. Woodard, I am going to request after pretrial give the history to see if there is information on his open case that currently went to felony first appearance today.
he didn't see the judge in felony yet.
Thank you for letting me know. I appreciate that, courtroom too.
You welcome.
All right, 23 CR 0057005B. Jarvis Woodard is charged with 1 count of theft by shoplifting and 2nd count of criminal trespass. Pre-trial.
22 total. Last arrest was on the 6th of this month. Possession of drug-related objects. On probation for simple battery out of Clayton County. 2023 theft by taking obstruction arrest. 2021 parole. 2017 parole. 2013 sale of cocaine, trespass, sale of marijuana conviction. That's it.
All right, state.
Yes, Your Honor. This happened September 3rd, 2023 at the Circle K at 160 Ted Turner Drive. The officer spoke with Annette Waldenstein, who stated that around 10 o'clock that night, the defendant grabbed 2 cases of beer and tried to exit the location without paying. Mr. Waldenstein tried to stop the defendant. The defendant dropped the beer, grabbed a bottle of Moscato wine, pushed past a customer and exited the store. The defendant then kicked the glass door, which damaged it by cracking it significantly. Currently, the defendant is being held on a robbery, battery, criminal damage to property in the 2nd degree and terroristic threats and acts case under 23 CP 222039, and he's being held on no bond on all of those charges. To that end, we understand the defendant's history. However, given that he is being held on that felony case, we are agreeable to a $3,000 signature bond through the jail, $1,500 per count. We did add the charge of criminal trespass, stay away from Circle K at 160 Ted Turner Drive, and no alcohol, drugs, or weapons. We'll also ask for no further contact with Annette Waldenstein, and I will put his name in the chat for the litigation manager.
All right, PD Finley.
Yes, Judge. Mr. Woodard is 33 years old. He is currently unemployed and he's currently homeless as well. I am going to send out an email and have a social worker get together with him so we can work on getting him an address for once he does work out or get out. He's from Dublin, Georgia, Judge. He does have community ties. That being said, as previously stated, he doesn't have anywhere to stay, and any sort of monetary bond would effectively be a no bond, as he wouldn't be able to afford anything. So he is being held on those other charges, so I am going to ask for a signature bond on these, Judge.
What was the state's recommended amount again?
$3,000 signature bond through the jail, Your Honor, $1,500 on each count. And again, that is solely in recognition of the fact that he is being held on that robbery, battery, cruel criminal damage to property in the 2nd degree and terroristic threats and acts. We feel that the bond that he will receive on that will be more than sufficient.
Okay. All right, I will order the $3,000 signature bond through the jail. I will order stay away from that Circle K, the incident location. No further contact with the, I guess it was be an employee or the victim in this case.
That is correct, Your Honor. That is the store employee.
Okay. Stay away from there, Mr. Woodard. Don't even go close. No drugs, alcohol, weapons, or guns while on bond. And I think that's it. Anything else?
Nothing from the state, Your Honor.
Okay, thank you.
Your Honor, we're gonna go to the add-on position,
Okay,
Mr. Luke Elliott Mayu.
This is 23 CR 005700A. Mr. Mayo is charged with 2 counts of simple battery family violence. Or are they on separate dates? I have 9/20 and 9/21.
It's 2 counts, Your Honor.
First arrest.
Thank you. State.
Your Honor, brief facts of the case is that on 9/20. Yes, on 9/20, basically on 9/20, there was an officer responded to a dispute at a location at 775 Woodland Ave, Southeast Atlanta, Georgia. The victim advised that her fiance assaulted her. Victim advised that defendant became mad because she was late to pick him up. And then she also arrived with her cat in the vehicle, at which point, out of his anger, he slapped her on the face. Defendant then threw her keys out of the window at Piedmont Park, and they were unable to recover the keys and had to take an Uber home. The incident spanned over the course of 2 days, 9/20 and 9/21. The second incident went into the second day. Later on that day, going into the next day, as I stated, defendant got upset because the victim chose to sleep outside because she was upset about the incidents that happened on the previous day. At that point, he pulled a blanket from her, causing her to hit the back of her head on the table. He also threw a trash can at her. Your Honor, the state is requesting at this time a $3,000 signature bond through the pretrial services, $1,500 on each count, a no contact, a family violence intervention program, and if no contact, then a stay away provision, and a no alcohol, drugs, or weapons at this time.
Alright.
And if we can sound for the victim, Miss Madison Miller.
Okay, Madison Miller. Madison Miller.
Your Honor, she's on. I think she just has to unmute herself and put her camera on.
Okay, Ms. Miller.
Sorry, hold on.
Wow.
Sorry, I'm new to Zoom. One sec.
Okay.
Hi there.
Okay. Would you like to address the court today, Ms. Miller?
Yes, my name is Madison Miller. Luke Mayo is my fiance.
Hold on a second. I need to swear you in first. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. What were you going to say?
This was a misunderstanding. It was one bad night, and he has never showed any aggressive behavior towards me. I would like him to come home, and I would like full contact with him. And I have full faith that this will never happen again. I'm not afraid of him.
You're ready to ask and you're not in fear. All right, any cross-examination by the state or by the PD?
No, Your Honor.
No cross-examination from the state, Your Honor.
All right. Thank you for your statement, Ms. Miller. You can hang on. And I'll make my ruling in a second.
Okay, thank
All
you
right.
so much.
All right, thank you. Go ahead, PD admin.
Thank you, Your Honor. My client is 37 years old. He was born in Georgia. He graduated from high school in Georgia, and he moved back to Georgia 2 years ago. And he's been living here for the past 2 years. He graduated from college at LSU and he studied broadcasting. He's gainfully employed at Warner Brothers Discovery. He only recently started working there about a week ago. He was supposed to be at work today, Your Honor, and the longer he remains in jail, the more likely he's going to lose his job. And this is a new job opportunity, and it is the only source of income for himself and his fiance at the moment. This is his first arrest. He is recommended. And as he is recommended by pretrial, and the fact that the complaining witness just testified that she's not afraid of him, she does want him to return home. This was a misunderstanding. And the fact that his future earnings and income will be impacted. I'm requesting a signature bond through the jail and a no further violent contact, and that he be allowed to return home.
Your Honor, the position of the state as it relates to no contact and a stay away is that it has not been a sufficient amount of cooling off time that has passed as the incident took place yesterday, essentially.
Your Honor, it's my understanding that a cooling off period is not statutorily required. There are 6 states that do require a cooling off period. Our state is not one of those. It really does sound like, after speaking with both the complaining witness and my client, that this really was a misunderstanding. They're planning a wedding. They're very stressed out, and they just want to get back and work this out and go on with their lives. So I am requesting a no further violent contact and that he be allowed to return home.
When are they getting married?
I'm not sure. We can ask him.
Okay.
November 11th, Your Honor,
When?
November the 11th.
Oh, November the 11th. Okay. All right. I will order that $3,000 signature bond. I'm going to order that signature bond be through pretrial. And they will tell you about the level of reporting. I'm going to order that 1-day anger awareness course through pretrial, and it's at no cost to you. I'm going to order, and I meant to ask, as far as this address on Woodland Avenue, do they both reside there or they do not?
Your Honor, it's the state understanding that they do.
And I understand that you're getting ready to get married in November, but I want to make sure that we aren't going to have any other incidents and that you would be able to get married and live happily ever after. But I do like to know that there has been some cooling down and some thought processes gone into whether I go back or not, and, you know, let you think about what's happened and be able to cool down and ensure that the victim is going to be safe, which I understand is your fiance. So your attorney will know what to do to ask for a modification. But right now I'm going to order that you not return to that location and that you have, I will say, no further violent contact since the victim was here or is here. But I'm going to order right now to stay away from that incident location. I will allow you to have a one-time law enforcement escort to return to that property to retrieve any personal items that you might need. And then if things are different, you can always ask your attorney to file a modification petition of that bond. And then there's also the 1-day anger awareness course through pretrial that you'll have to take. All right, that's my ruling for now.
So
Your Honor, there's going to be no further violent contact or no further contact.
Oh, because it's the stay away.
well, no, I'm just asking.
Well, I think I said no further violent, but I do want the stay away, I believe.
Yeah, Your Honor, we are objecting to the stay away. I understand that you do want them to have a cooling off period. However, like I stated, that is not statutorily required. And I think due to the facts and circumstances that we've heard, as I've said, this was a misunderstanding. They're getting married in a month or so. It sounds like he is he's the primary breadwinner. He does help pay the rent. And I understand he does have another place to stay, but it is not nearby. And so I'm asking Your Honor to reconsider and allow him to return home.
And Your Honor, if I may humbly add that I have been reflecting very somberly and deeply on my actions over the last 48 hours, and this has been a cooling off period, if you will. I'm very in love with my wife, and I greatly wish to work this out with her and her alone. But I respect the decision of the court. Thank you.
And Your Honor, if I could briefly add that if Your Honor so fits, the victim can apply for a modification at a later date if Your Honor orders a stay away and a no contact at this time.
And it's the defense's position that it's clearly not necessary at this time, but we will respect your decision, Your Honor.
And the allegations are that there were keys thrown. Is that what it was?
Yes, Your Honor.
Well, the allegation specifically was that he threw a trash can at her. He grabbed a blanket from her, causing her to hit her head on the back of a table, and that he slapped her in the face. And in addition to that, there were keys thrown out of the car, and ultimately she lost her keys and could not find them.
Right. And I just do want to add that these are allegations at this time, and he is being monitored through pretrial. He is being required to take a 1-day anger awareness course, although he still maintains his innocent until proven guilty. These are allegations, and I would ask Your Honor to impose conditions only reasonably necessary to ensure the safety of the complaining witness, and that he will return to court. And I think that the stay away is not necessary at this time.
And lastly, Your Honor, this wasn't as the result of a mutual argument. This was as a result of her showing up to his work late and with a cat that he, I guess, lost his temper.
The complaining witness testified that the allegations were that it was a misunderstanding. And so the allegations, as they're stated, were clearly contested.
May I please
All right.
interject, Your Honor?
Quickly.
Yes, ma'am. He did not slap me. That was an overreaction. He did not slap me in the car. We did have to pull over because we were having a heated verbal argument, but he did not slap me. He did throw my keys, but I would like to correct that information. He threw a trash can in my direction that was on the porch, but it never hit me. None of this.
Who called the police?
I did.
Okay.
So,
All right.
and then as they were taking him out, I asked, can we please reverse this, work this out? And they took him anyways, but I begged and pleaded for them to not take him away. I really am not afraid of him. And I do believe that he has done some serious self-reflection, and that anger management would be like enough of a reality check. That's how I feel. I genuinely believe that. Okay. I love him. I will come home.
Okay. All right. I've done the signature bond through pretrial, the anger awareness course. I'm going to order stay away from 775 Woodland Avenue Southeast. I will allow no further violent contact, but I want him to find somewhere else to live for a moment to make sure that you are beyond this and you will get through it. And his attorney can file a motion to modify it as soon as things have worked themselves out, hopefully for the two of you, and gotten back to normal. But I do want him to stay somewhere else for some time to make sure that he understands the gravity of it, and that with his anger awareness course, he gets some assistance or ideas on how to deal with his anger. You all are just beginning and just starting out. And so I feel like, I want to make sure that you're going to be safe and that things are going to be turned around. And a little bit of distance, I think, will ensure that there will not be any more incidents. Okay. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
No drugs, alcohol, weapons, or guns while on bond. I don't think I said that.
We completed here in courtroom 2.
Okay.
Be excused.
I guess you can go have a little bit of a weekend unless you have to come back tomorrow.
I'll be here tomorrow.
Your Honor, do you know who's on the calendar for tomorrow as far as the judge?
Tomorrow, yes, I think is law.
Okay, thank you.
All
So
right.
we don't need to worry about the other guy? I'm just asking. The
Which one?
ODEH.
See, pretrial missed me saying he was released on a $10,000 surety bond through Second Chance Bail Bonds Company.
He sure was. He sure was too.
Now they're gonna talk about you, Mr. T, as I say. You know they're gonna mess with you. You're not gonna answer them because you don't want to say anything bad.
They got me.
Okay, they got you. That's good. I like when you admit that you've been gotten, as they say. All right, have a good weekend.
Have a great weekend. It's been a pleasure,
Oh,
Judge.
that's right. We have to reconcile real quick. You want to do that? We've got a little bit of time to do that.
Yes, please.
Okay.
Position number 1 is a $3,000 good bond reset, SAP 10-5. Position number 2, defendant was released, reset further notice. Position number 3 is a $2,000 sign on bond through the jail, reset further notice. Position number 4 was a null pros. Position number 5 is a $2,000 sign on bond through the jail, reset further notice. Position number 6 is a total of a $10,000 good bond reset, SAP 10-5. Position number 7 is a total of a $1,000 SOB through the jail. It's going to be reset further notice. Position number 8 is a total of a $3,000 SOB through the jail, reset to the SAP calendar 10-5. Position number 9 is a $3,000 pretrial bond per judge, reset further notice. Position add-on 1 is a total of a $3,000 pretrial bond, reset further notice. Any questions?
Nope. That's what I've got. All right, everybody, have a good one.
Thanks.
All right,
Thank
thanks.
you.
All right, bye-bye.